Mr. Cox, can you hear me?
Can you hear me?
Yes, thank you. Hey, I was going to ask each of you, would both of you be, or one or both of you be available on Monday at 1 p.m. for a pretrial hearing on the Spain case?
Sure.
Okay. I've conferred with Joe Murphy. He's available at 1 p.m. We're trying to line Judge Banner up. It's a required COVID hearing that has to be held 7 days, at least 7 days before trial. So y'all can go over the logistics and everything. So I plan on having Judge Banner here that Monday and discussing with him the changes in the courtroom and jury selection. But there has to be that hearing to allow the defendant to file any objections to the trial. And I don't believe at this time Mr. Murphy's interested in objecting to anything. So, but it is required. So I just want to make sure you guys would be available and it's not a typical criminal docket.
No, we can do that.
Okay. And if you want to appear via Zoom, I can have all that set up. I'm not sure if Mr. Murphy's going to be here or not, but I told him he could appear Zoom or in person, that we could set that up for him. So I'm sure that Mr. Spain will probably be appearing via Zoom. So if you wanted to appear via Zoom, we could arrange that.
Okay.
Okay. So, all right, I'll have Patty send a notice of hearing or an email to you for that.
Sounds good.
All right, I'll go back in my holding pattern. Y'all just let me know when you're ready.
Judge, I think we're ready.
Okay.
We've got Ms. Hughes. Sorry, you're.
Hello, Ms. Thompson. How are you?
Good afternoon, Your Honor. I'm fine.
All right, court calls CR 2216, State of Texas versus Jeannie K. Hughes, and we're set for arraignment today. Is that correct?
Yes, Your Honor, that is correct. We have received a copy of the indictment. She is a beauty. Her name is spelled correctly. She does understand what she's charged with. For purposes of today's hearing, we enter a plea of not guilty and waive the reading of the formal indictment, Your Honor.
Thank you, Ms. Thompson. The court will enter Ms. Hughes' plea of not guilty into the record, and court will set this for pretrial hearing. Are you available on December 10th? It's a
Sorry
Thursday.
to interrupt, Judge. We actually, oh, I'm sorry. I took Ms. Elwood. Okay. Disregard, Judge. Sorry.
Okay.
I'm sorry, what did you say, Your Honor?
Are you available for a pretrial hearing on December 10th?
I believe I am, Your Honor.
Okay. The court will set for pretrial hearing December 10th at 9. And I see that Ms. Hughes is not currently incarcerated. Did you make bail, Ms. Hughes?
Yes, sir.
All right, well, thank you for being here. And we'll set that at 9 a.m. That means, Ms. Hughes, the next time you'll come to the courtroom as long as you're on bail.
Yes, sir. May she be excused, Your Honor?
Yes, but Ms. Hughes, have you received the court's copy of the conditions of pretrial release? Have those been provided to you?
I don't believe they have, but I think they're probably fixing to be.
Okay, is Ms. Wood, I'm sorry, is Ms. Burns over there?
I am.
Okay. Will you check to see if Ms. Hughes has conditions of pretrial release? If not, we need to get some filled out by her. And if you want to set her to come to your office and fill those out, we can do that as well at another time. And I can get those signed. But since Ms. Thompson has been appointed, she's going to be required to have conditions of pretrial release. So, Ms. Burns, however you want to handle that, if you want to have her report to your office now, and I can send some over, have Ms. Taberham email them over, and we can have them filled out over there, or...
If you don't mind emailing them to me, Ms. Taberham can email them, and I'll have her sign them here and give her a copy here.
Okay. All right. So, Ms. Hughes, have a seat. We're going to get some paperwork for you, and then we'll get you out.
Just go ahead and set up.
Okay, thank you.
Yeah, sorry. I got them in my head.
Miss Hazel.
Oh, here's the court document.
All right. right, will Miss Elwood be a plea today?
Yes, Your
Yes.
Honor.
Okay. And Ms. Heisel, can you tell me the terms?
Yes, Your Honor. There's an agreement for Ms. Elwood to plead to the lesser included Class A assault, family violence. Sorry, I already said Class A misdemeanor. Upon a plea of guilty, the state is going to agree to 122 days confinement in Van Zandt County Jail with credit for 122 days. And the state is going to 1245 cause number 2020-00017, which is a misdemeanor resisting arrest. There's going to be a $100 fine, $270 court costs, and $845 in reimbursement, Your Honor.
All right, and she's currently charged with a third-degree assault impeding, and it's to a lesser-included Class A assault family violence, correct?
That's correct.
All right, Miss Elwood, if you will, raise your right hand. I'm going to place you under oath. Miss Elwood, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir, I do.
All right, you may put your hand down. Are you Crystal Rose Elwood?
Yes, sir.
And Miss Thompson, Miss Elwood has not been arraigned today. Is that correct? She's not been arraigned in this case.
No, she is not, Your Honor.
Okay. So let me ask you, Miss Elwood, do you understand that you have been charged with the third-degree felony offense of assault of a family or household member by impeding breath or circulation, which carries a range of punishment of 2 to 10 years in prison and a fine not to exceed $10,000? Do you understand that?
Yes, I understand what you said.
Okay. And you heard Ms. Heisel from the DA's office tell the court that there's an agreement in this case in which you're going to plead guilty to a lesser charge of Class A misdemeanor assault family violence with a recommended sentence of 122 days in the county jail with credit for 122 days with the dismissal of the resisting arrest charge, and you would receive a $100 fine and $270 court cost and $845 reimbursement fee. Is that your understanding of your plea agreement with the state?
Yes, sir.
And in this case, you are represented by your attorney, Ms. Ann Thompson. Do you feel like you've had sufficient time to discuss the case with her and have all of your legal questions answered?
Yes.
And is there anything about the paperwork that you've read and signed that you do not understand?
No, sir.
And your signature appears throughout those documents. Is that your true and correct signature?
Yes, sir.
You only signed that certifying that you understood everything that you read and signed. Is that right?
Yes, sir, it is.
And Ms. Thompson, is your client competent today?
Yes, she is competent, Your Honor.
And Ms. Elwood, have you ever been diagnosed with any type of mental condition?
Yes, sir.
What have you been diagnosed with?
What have I been diagnosed with? Bipolar 2, manic depression, anxiety, insomnia, PTSD.
That's a lot.
Yes, sir.
Are you currently on medication for any
No,
of them?
sir. No, sir.
Do you feel like the fact that you're not on medication has in any way prohibited your ability to rationally understand the proceedings that are going on here today?
No, sir.
And Ms. Thompson, you haven't seen any signs or symptoms of any of those mental disorders that causes you any concern regarding her competency. Is that right?
That's correct, Your Honor. Just some anxiety, which I would expect.
Okay. All right, Ms. Elwood, to the Class A misdemeanor offense of assault, family violence, how do you plead?
Guilty.
And Ms. Elwood, are you pleading guilty to that lesser charge because you're guilty of that charge?
No, sir.
Ma'am,
No, sir.
you're not guilty of committing assault.
Yes, sir. I'm guilty.
All right, so listen, I'm just going to ask you. I understand what you're saying, but I'm going to ask you just so that we can have clarity on our record. I have a court reporter here with me in the courtroom.
Yes,
She's
sir.
typing down everything that we say. Okay, so let me
Yes,
just
sir.
let me ask you again.
If you could repeat the question, please.
I will.
Okay.
So You've been charged with a third-degree felony offense of assaulting a family or household member by impeding breath or circulation. But the plea agreement in this case calls for the lesser charge of assault family violence, a Class A misdemeanor. My question to you, Ms. Elwood, is are you guilty of committing assault family violence?
Yes, sir.
And are you pleading guilty to that because you are guilty of that lesser offense?
Yes, sir.
And has anyone threatened you, forced you, or pressured you to plead guilty to that lesser offense?
No, sir.
All right, the court accepts the defendant's plea of guilt. Ms. Thompson, is there any objection to States 1?
No objection, Your Honor. I would like to take my client under oath for briefly.
Okay, just a moment. All right, the court admits States Exhibit 1 into evidence and takes judicial notice of the defendant's judicial confession. And Ms. Heisel, is there anything further from the state? Any kind of
No, Your Honor.
victim impact statement or anything of that nature?
There is an affidavit of non-prosecution on file in this case, Your Honor.
Thank you, Ms. Heisel. Go ahead, Ms. Thompson.
Go ahead and state your full name for the record.
Crystal Rose Elwood.
I noticed that you're a little bit confused and anxious here today. Is that correct?
Yes, ma'am.
Now, I came in early and met with you, and I've also spoken with you by telephone. Is that correct?
Yes, ma'am, that is correct.
So you do understand what's going on here today?
Oh, yes,
All right?
ma'am, I do.
Okay.
Yes, ma'am, I do.
Just to make it clear to the court that it was explained to you in detail, and you knew what you were pleading to.
Yes,
If
ma'am.
you chose state, please.
Yes, ma'am, that is correct.
Pass witness, Your Honor.
No questions, Your Honor.
Okay. Can you go ahead and give me a brief summation of the facts, Ms. Heisel?
Yes, Your Honor. Miss Elwood and her mother were basically involved in an argument, and Miss Elwood is accused of shoving her mother, pushing her, pulling her hair, and grabbing her by the throat and choking her. There was a witness that confirmed that to the officers, and then Miss Elwood was placed under arrest for that impeding charge.
Ms. Thompson, any objection to Ms. Heisel's summation?
No, Your Honor.
All right, then based on the evidence before the court and the state's recommendation, the court will find that there is sufficient evidence to convict Ms. Elwood of this lesser included offense of assault, family violence, Class A misdemeanor. Court assesses her punishment within the range of punishment, which is to not exceed 365 days. The court assesses her punishment at 122 days confinement in the Van Zandt County Justice Center. The court will grant Ms. Elwood 122 days credit for time already served. The court dismisses under Section 1245 of the Texas Penal Code, cause number 2020-00017, resisting arrest. The court assesses a $100 fine, $270 court cost, and $845 reimbursement fee to Van Zandt County. Ms. Elwood, upon being released, you need to make contact with the court's collection officer, compliance officer, to make arrangements to discharge your fine, court costs, and reimbursement fees that you owe the county. Your failure to do that will result, and your failure to pay will result in the court issuing a warrant for your arrest. You're going to be right back in the Van Zandt County Jail. Do you understand that?
Yes, sir, I do.
So as soon as you get out, you need to make contact with Ms. Bonnie LaPrade here in the Van Zandt County Courthouse.
Yes, sir.
All right, the court hereby remands Ms. Elwood to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step to your left to be fingerprinted with the bailiff. Good luck to you.
Thank you very much. You as well.
No, that's all I have for the afternoon, ma'am. Excuse, sir.
Are we through with Ms. Hughes?
We are through, Missy.
Okay, and I gave her the date of December 10th, correct?
That's correct.
Mark that down. Okay, yes, thank you, Ms. Thompson.
You're welcome, sir.
Judge Martin,
Yes, ma'am.
Your Honor, we do have Carl Davis in the room if Ms. Beasley is available.
I see something that says iPhone. Let's see if that's her.
Yes, sir. Yes, ma'am. Thank you.
Happy birthday.
Hey, if he comes early, I'll take him to lunch. Don't tell him that. Ms. Beasley, can you see and hear me okay?
Mr. Davis, come on up, sir.
You may be muted, Ms. Beasley. I'm not picking you up. There may be a microphone on your device. You may have to swipe up to see the microphone. I'm not showing you registering with any microphone right now. Ms. Beasley, let's try this. I'm going to put you back into the waiting room, and then I'm going to attempt to pull you back into the hearing. And perhaps when I do so, you'll be prompted to join with audio and video. You can't hear me? Let's try this. No, ma'am, I can see you moving your lips, but I cannot hear you. I'm not showing on my side that your audio, that your device is equipped for audio. Are you on your smartphone? Can you hear me okay? You can't hear me? No, cannot hear you. Looks like we have lost Miss Beasley. Mr. Davis, why don't you go ahead and have a seat? It might be a moment. You can just stay right there behind you. We'll see if she can reconnect. Still nothing, Ms. Beasley? Ms. Beasley, if you can hear me, you should be able to swipe up and find that red microphone. I see that you have it available now. You just have to find that icon. So swipe up or swipe left or right, find that red microphone and click it, and we should be in business.
I got it.
There you go. I had faith in you. All right, here we go. Thank you, Mr. Davis. Okay, this is cause number CR 20-00008, State versus Carl Ray Davis, and I believe we're set for pretrial hearing today, Ms. Beasley.
Yes, Your Honor. I'm going to need an additional pretrial setting. I don't think that I have the DVDs available in this case. In addition to that, just recently, within the last day or two, I have some witness statements that I was able to obtain that I need to provide Mr. Cox.
Any objection from the state?
No, Your Honor.
All right, are you available on December 10th, Ms. Beasley?
I'm already set, I believe, December 8th, if that's available to the court.
Well, I think December 8th is pushing over 40 cases now, so I've got to keep the number lower so I don't violate the court's COVID plan. So I've got December 10th, December 8th is full. December.
Let's set it for then, Judge. If I have a problem, I'll notify the court because I don't want to come out of the screen. I knew I was available for December the 8th.
Okay. It is pre-trial, so if you need to appear via Zoom, obviously you can do that as well.
Okay. Thank you, Your Honor. I appreciate it.
You're welcome. All right, so we'll set this case for pre-trial hearing on December 10th at 1:30 if it's jail, 9 a.m. if it's bail.
Yes, sir.
And Deputy McLeish here is going to have Mr. Davis sign his notice of appearance.
Perfect. And I'll be out to see him as soon as I have any information.
Did you hear that, Mr. Davis?
No, sir, I didn't.
Say that again, Ms. Beasley.
I'll be out to the jail to see you as soon as I have any new information.
Yes, ma'am.
All right, then we'll be adjourned in this hearing.
Thank you, Judge.
Thank you.
Appreciate it.
Yes, sir. You go with my partner in the corner there.
All right, so court will just stand in recess until Mr. Martinez is ready on his plea or Mr. Grubbs is ready on his plea.
Yes, Your Honor.
Thank you, ma'am. Hello, Mr. Hyde. How are you, sir?
Good, Judge. How are you?
Doing well, doing well. Let's see. This is Mr. Cruz, is it not?
It is, Your Honor.
All right, court call CR 19-181, CR 20-54. Believe that we are set for plea today. Are we conducting a plea?
Your Honor, we've reached an agreement on a plea. Mr. Cruz's wife is having to have a heart procedure. We're requesting as he's going to be entering a plea of prison time. We've signed a jury waiver today in court, waiving any jury, and asked for a date to come back in December for him to plead and start his sentence.
Is the state in agreement?
We are, Your Honor.
And how long would you be requesting, Mr. Hyde?
Whatever your court dates are in December, 7th, week of the 7th, 14th, whatever. I don't know what your calendar dates are.
How long would his wife need for a medical procedure?
Else, yeah, 2 or 3 weeks.
And what's the plea agreement?
20 years in prison on 2 cases run concurrent.
All right, court will reset Mr. Martinez for December 10th at 1:30. And you have that jury trial waiver with you now, Mr. Hyde?
Yes, we've signed it and given it back to the state.
And state, you join in with the defendant requesting waiver of jury trial?
Yes, Your Honor, and I've given the signed copy to Deputy Leash for her to bring over to the court.
Mr. Martinez, I'm going to have you raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Mr. Martinez, you understand that you have the absolute right to have your case presented to a jury of your peers?
Yes, sir.
You understand that you have the right to subpoena witnesses, to cross-examine and confront the state's witnesses and the evidence that they intend to bring against you. You understand that inside that right to have your case tried before a jury of your peers, you also have those rights.
Yes, sir.
And you understand that no one can take those rights away from you. However, you and only you can waive those rights.
Yes, sir.
And you're asking the court to allow you to waive your right to a jury trial. And by doing so, you understand that that right may not be restored to you except for under very limited circumstances.
Yes, sir.
And are you doing this of your own free will and accord? No one's threatened you, forced you, or pressured you to waive your right to a jury trial. Is that correct?
Yes, sir.
All right, the court will take judicial notice that the waiver of jury trial has been signed by the defendant, defense counsel, Mr. Heath Hyde, and has been joined by the attorneys for the state. The court hereby approves the waiver of jury trial and sets pretrial on December 10th at 1:30 p.m. I'm sorry, sets it for plea on December 10th at 1:30 p.m. Once you sign your notice of appearance and receive the yellow copy, the court will retain the white copy. You'll be free to go.
Thanks, Judge. That's all I have.
Thank you, Mr. Hyde.
You guys have been in touch with Mr. Ashman?
Yes, we have paperwork and on the way here to the business line.
Okay, thank you.
All right, we're just waiting on Mr. Grubbs.
Yes, sir. Mr. Ashmore, Mr. Grubbs. Yes, sir.
Okay, we're waiting on it.
Yes, sir.
All right, I'll be here, ready and willing.
We'll let you know.
All right, thank you.
Yep.
Switch the keys.
All right, Mr. Grubbs, if you will, raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you may put your hand down. You are Justin Richard Grubbs, is that correct?
Yes, Your Honor.
Mr. Grubbs, you are represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
Yes, sir.
Feel like you have had sufficient time to talk about your case with him and have all of your legal questions answered?
Yes, sir.
Have you taken the time to read and understand everything that you've signed?
Yes, sir.
And your name, as it appears in those documents, is that your true and correct name?
Yes, sir.
You've only signed to certify that you have read and you agree.
Yes, sir.
Correct?
Sir.
And are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
And Mr. Ashmore, do you believe Mr. Grubbs to be competent today?
Yes, Your Honor.
And you've explained to him his legal and constitutional rights?
I have, Your Honor, in particular, the deferred adjudication and how that carries the advantage of restoring all of his rights upon successful completion, as well as the danger of the full range of punishment on a second-degree felony if there's a motion to adjudicate guilt or motion to revoke for failure to comply with probation conditions.
Okay. And Ms. Heisel or Mr. Cox, what are the terms of the plea?
Your Honor, it's 6 years deferred adjudication probation with a $2,000 fine.
Court costs?
Yes, sir. Court costs and attorney's fees.
How much are those?
$290 court costs, restitution of $180, that's for the drug test, and then reimbursement fees of $1,010.
And it is to the plea to the charged second-degree felony possession of controlled substance, penalty group 1, greater than or equal to 4 grams, less than 200.
It is, Judge. It's also resolving case DA 2020-0834 on it's a 1245 of M19-00657 and another PCS penalty group 1 that is number DA 2020-0833. So it's a 1245 of those additional 2 charges, Your Honor.
What was the DA 2020-00383?
It's DA 2020-0833, Your Honor.
All right, so just those 2 charges, M19-657 and DA 20-0833.
Yes, Judge.
Okay. All right, Mr. Grubbs, the range of punishment for a second-degree felony offense of possession of controlled substance in penalty group 1, greater than or equal to 4 grams but less than 200 grams, is confinement in the Texas Department of Criminal Justice for a period of not less than 2 years or a period more than 20 years, and a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
You understand that if the court approves this plea agreement and places you on community supervision, that if you violate the terms and conditions of your community supervision, the state could file a motion to adjudicate your guilt. And if they prove to this court that you violated, you would not have a right to a jury trial regarding possession of controlled substance. The court would only inquire as to whether or not you violated your community supervision. Do you understand that?
Yes, Your Honor.
And if the court finds that you did violate your community supervision, the court could revoke you from probation and could set your sentence anywhere between 2 years and 20 years. You understand that?
Yes, Your Honor.
All right, so Mr. Grubbs, to that charge, how do you plead?
Guilty.
Are you pleading guilty because you are guilty of that for no other reason?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty to this charge?
No, sir.
All right, the court accepts the defendant's plea of guilt. Mr. Ashmore, is there any objection to States 1?
No, Your Honor.
Court admits States 1 into evidence and takes judicial notice of Mr. Grubbs' judicial confession. Is there anything further from the state?
No, Judge, rest and close.
Thank you. Anything further from the defense?
No, thank you, Your Honor.
All right, Mr. Cox, can you give me a brief summation of the evidence?
Yes, sir. Canton police officers stopped the defendant because he was walking in the wrong direction on the shoulder of 198. When they stopped him, they patted him down for officer safety, and in his pocket located methamphetamine.
Thank you. Mr. Ashmore, any objection to that summation?
No, that's accurate, Your Honor.
All right, then based on the evidence before the court will find that there is sufficient evidence to convict Mr. Grubbs of this offense. However, the court will follow the plea agreement and the recommendation of the state. The court hereby defers a finding of guilt in this matter, places Mr. Grubbs on 6 years deferred adjudication. The court assesses a $2,000 fine, $290 court cost, $180 restitution, orders him to reimburse Van Zandt County in the amount of $1,010. The court dismisses under section 1245 of the Texas Penal Code unfiled cause numbers M19-00657 and DA 2020-0833. Court hereby remands Mr. Grubbs to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. Mr. Grubbs, you have went over your conditions of community supervision, have you not?
Yes, sir.
And you understand what's expected and required of you?
Yes, sir.
Okay. All right, upon being released, Ms. Burns is there in the courtroom with you. You'll need to speak with her about when you're to report. And once you get there, you report and learn what you need to do to stay in compliance with your probation. You understand?
Yes, sir.
All right, good luck to you.
Thank you.
Don't need to call me then. Okay. Thank you, ma'am.
Thank you, Mr. Ashmore. Appreciate you.
Thank you, Judge. May I be excused?
Be careful.
All right.
We're done.
All right.
This lady, she's in the courthouse, okay? She'll have you set up a payment plan so you can get that taken care of.
Judge, is that all we have?
Yes, sir. That's all we have.
We be excused?
Yes, sir. Thank you.
Thanks.
Thank you guys for catching that.